know some of you, I got it. All right. We know some of you already employ staff and independent contractors, and others are just starting to think about it. But regardless of your status right now, there's something here for all of you, and we're very happy that you're here. I just mentioned that we do plan to record tonight's presentation, just the slide portion. If you have any reservations about that, again, just my name is Amy, and just reach out in the chat to share any concerns you might have. Speaking of, I'm going to introduce myself at the Community Law Center and our wonderful presenters tonight. But as I do, I encourage anyone joining. Mr. Payton, you might have joined after I did this. Ms. Powell, anyone who's joining the chat, joining the Zoom and wants to put in the chat what organization they're with, and if they have employees or are just thinking about it in the future, we would just love to see where you are in your organization now. So my name is Amy Yontef-McGrath. I'm the pro bono coordinator at the Community Law Center. The Community Law Center, as you know, provides legal services to community and nonprofit organizations throughout Maryland to promote stronger and more vibrant neighborhoods. We provide regular workshops like this and offer legal representation for a variety of legal issues, ranging from nonprofit formation and 501c3 to impactful litigation on behalf of communities, and really everything in between, like leasing and transferring real property, negotiating contracts, protecting intellectual property, and employment matters like the ones we're here to talk about tonight. Should you become a client of the Community Law Center, and I hope you will if you're not already, and I am going to share at the end of this presentation how to become a client and how to do that. And if you don't get the opportunity to work with one of our amazing staff attorneys, two of whom are on the call, Shana Roth-Gormley and Denise Coe, then you're going to be working with me as I work to connect you and match you to a terrific and skilled volunteer attorney. And speaking of skilled and wonderful volunteer attorneys, I have the pleasure to introduce our guest speakers for tonight's workshop, Bethany Ingle and Alex Berg. Bethany Ingle is a shareholder in the Tysons Corner, Virginia office of Littler Mendelson, PC, where she represents and counsels employers in a wide variety of industries to ensure compliance with federal, state, and local laws, addressing discrimination, harassment, retaliation claims, as well as independent contractors and workers' compensation issues. Bethany assists clients with developing employee handbooks and workplace policies, in addition to advising them on performance management, including hiring practices and termination. Bethany is a 2009 graduate of the University of Richmond School of Law and worked as an assistant public defender before practicing employment law. Bethany is licensed in Maryland, Virginia, and admitted to the federal courts in Maryland, Virginia, and the District of Columbia. Alex Berg is of counsel in the Tysons Corner, Virginia office as well of Littler Mendelson, where he represents and counsels employers of all sizes on a variety of labor and employment law issues. These issues often range from front-end training and compliance assistance to high-stakes class or collective action litigation under such laws as, there's going to be a lot of letters here, Title VII, the ADA, the ADEA, the FLSA, and the FLMA. Alex is a 2011 graduate of the Georgetown University Law Center, previously served as a judicial law clerk on the Maryland Court of Special Appeals and the DC Superior Court, and is licensed to practice in Maryland, Virginia, and DC. You can see why I'm so proud to introduce these two wonderful attorneys tonight, and I want to turn it over to them. Let's begin. Thank you so much.
Thank you all for joining us this evening. So we want to go over some of the basics of employment law. And on the agenda tonight, we thought we'd cover employees versus independent contractors, how to distinguish between the two. There are a lot of laws that are encompassed under the umbrella of employment law that call for distinguishing between the classification of workers as employees versus independent contractors. So we'll get into that in more detail. We'll talk about various federal and state employment laws, ones that cover both the payment of workers as well as the protection of workers for various protected categories such as race, gender, disability, various reporting requirements when you start to hire employees in the state of Maryland, or just generally when you become an employer, hiring and firing best practices, employee handbooks, and nonprofit bylaws, how those differ, and some best practices there. And then we ask that you put any questions that you may have in the chat during the presentation, but we'll address the questions towards the end of the presentation. And so getting into the topic of employees versus independent contractors, this is something that really preoccupies a lot of the practice of an employment attorney, a lot of the advice and counsel that we give. And so really there's often a debate over whether someone is properly classified as an employee or an independent contractor. Just calling someone a 1099 because that's the tax form that they're going to receive at the end of the year because you haven't withheld any taxes from their paycheck does not make them an independent contractor. Just calling them an independent contractor or having them sign a piece of paper in which they acknowledge that they're an independent contractor is not going to make them an independent contractor under the law. There are various factors that various laws will look at, federal law, state law, in order to determine if someone is in fact an employee or an independent contractor. And so this distinction is really important because employees, as you know, are covered by various laws such as the Fair Labor Standards Act, or FLSA, as you heard in the description for Alex's job earlier. And this is the law that ensures employees are paid minimum wages as well as overtime rates for any hours worked over 40 in a regular work week. Employees are also entitled to protections from discrimination under federal employment law, which we'll discuss in more detail later. They're also entitled to workers' compensation benefits if they're injured on the job, and they may be entitled to paid sick or family medical leave, depending on the size of your business. And employees can get unemployment insurance in most situations when they're terminated from employment. And as you're probably already aware, there are also certain tax obligations that you as an employer would have if someone is an employee versus an independent contractor. Independent contractors, on the other hand, are not entitled to all of the benefits that I just mentioned, and they're essentially supposed to operate as their own separate business entities. You don't have to withhold taxes from their pay. You don't have to provide them with workers' compensation benefits if injured on the job. And you don't have to ensure that they're earning at least a minimum wage or getting paid for any overtime. So working with independent contractors sounds a whole lot easier than hiring employees, doesn't it? Why can't we just classify everyone as an independent contractor and avoid all the trouble of having employees? As I mentioned, there are laws designed to ensure this does not happen. All the laws that we'll get into in plenty of detail throughout this presentation to protect workers from things like discrimination and making sure they're paid fairly. As I've noted, those don't apply to independent contractors, those apply to employees. And so that's why various federal laws, state laws want to ensure that people are properly classified as employees when they are in fact employees. And these tests under the various laws for whether someone's an employee or independent contractor, they do vary by state, by federal law, depending on whether you're talking about someone's pay, whether you're talking about entitlement to workers' compensation benefits. And I'll tell you that it varies by state. States all look at these issues differently. But one thing that these tests all really do have in common is the degree of control that the company exercises over the worker. So the less control the company has over the worker, then the more likely they are to be an independent contractor. So things to take into account is For example, are you dictating how the work is to be performed? Are you providing the workspace? Are you providing all the tools and equipment needed to perform the work? Are you telling the worker exactly when they have to perform the work? Do you give them a schedule? Do you mandate that they wear a uniform? Do you issue discipline and performance evaluations? Do they have a supervisor who works for your company and is an employee of your company? Do you pay them by the hour instead of per task performed? For example, did you hire someone just to perform a discrete marketing task for your business when you don't otherwise have an employee who performs a marketing function for your business? And you didn't really tell them exactly how to perform their marketing service. And they perform marketing services for all sorts of different businesses, and they work on their own schedule. You don't call them up on Monday and say, hey, where are you? Why aren't you here in my office performing marketing services? If you're not doing those sorts of things, and this person's free to engage in their independent marketing business by their own terms, in all likelihood, yes, they are an independent contractor that you've just contracted with to provide that particular service for your business. They are not your employee. You don't control how they perform their work. You said, I want you to perform this particular work, and I want it to look something like this, and I'll pay you this much money for it. But otherwise, you're not controlling or dictating how they perform the work that you as a business don't normally perform. That's really a good example of an independent contractor relationship. But where we see this getting murky is when, for example, businesses have employees performing certain tasks, and then they'll hire independent contractors to perform those same tasks. Then it's unlikely those workers who are performing the same functions that employees are performing are in fact independent contractors instead of employees. Under the law, it's likely, especially if those workers are being told to do the same things that your employees are being told to do, have a supervisor, the same supervisor that your employees have, that under the law, they're not going to be viewed as independent contractors. They're going to be viewed as employees, and there are penalties imposed under various laws for misclassification of workers. So you'll want to be very mindful of these distinctions. They have ramifications both in the wage and hour field of employment law and carry penalties there. I see it a lot in workers' compensation practice, where people don't have coverage for certain types of workers because they say they are independent contractors when that person doesn't maintain insurance coverage for themselves and they get hurt while performing work. And the workers' compensation laws may have a different test for whether or not someone is considered to be an independent contractor or an employee. So this is a very important aspect of employment law, is first determining whether they're actually employees or independent contractors.
That's right. And I would just add to that, very well put point, Bethany, that right, whatever value you might think it would have in terms of shortcuts or the ease of classifying as somebody as an independent contractor on the front end, I think we could each spend an hour on other stories of where that boomerangs around on the back end, because even either it's clear that they were misclassified, and then the maze of employment laws ends up ensnaring the business, the nonprofit, in rather expensive proceedings, but also it just becomes difficult, even in those closer cases, to tease things out. And oftentimes, if you end up on an auditing agency's radar, for example, the costs of proving that you're right can easily exceed the amount that's in dispute. So all of which is to say, the sort of measure twice, cut once philosophy applies particularly here. If you're going to classify somebody as an independent contractor, be prepared, and you may want to keep notes for yourself, for example, as an owner, about why you reached a certain decision related to that classification. There's also some publicly available resources out there with respect to things like the U.S. Department of Labor prepares free of charge opinion letters that sometimes may have bearing on types of individuals, types of workers, and whether they either would be deemed to be independent contractors, or certainly also, depending on job title, can weigh in with helpful feedback on whether somebody is an exempt employee who is not owed overtime, or a non-exempt employee who is owed overtime, which we'll get into in a little bit. But Bethany, do you want to talk about volunteers now?
Sure. Yeah, thank you, Alex. And I'm glad you did bring up the Department of Labor opinion letters. There is an opinion letter that does touch on volunteers, because the U.S. Department of Labor does weigh in on this. So typically, volunteers are people who donate their time without receiving any financial or material gain, and they can receive tax deductions on their income taxes for certain expenses that they've incurred for providing their services to your organization. Volunteers can only really qualify as volunteers if they're providing their services to a charitable organization. So they can't be volunteering for for-profit organizations and really be considered volunteers. Really, that would be free labor. For-profit organizations, like some restaurant is just like, hey, we need somebody out here, helping us move traffic through the drive-through line, so why don't we get a few volunteers out here? No, that wouldn't qualify. Those would not be volunteers. You would need to pay them for their services and abide by employment laws, since you are a for-profit business as a restaurant. But the Department of Labor has said that typically volunteers serve on a part-time basis, and they do not displace regularly employed workers or perform work that would otherwise be performed by regular employees. So that's something to keep in mind. It's not that they can't perform the occasional task that an employee may perform, but they shouldn't be displacing or just working for free in roles that are also filled by employees for the organization. This is something that's part-time in nature, occasional, and doesn't otherwise take up the same role that an employee in the organization would have, or displace an employee for essentially free labor here. The Department of Labor has also said that paid employees of nonprofits cannot volunteer to provide the same type of services to their nonprofit organization employer that they're ordinarily employed to provide. In other words, you can't ask one of your employees to perform some of their regular job duties on a volunteer basis and then not pay them for those volunteer services. So let's say you've got a receptionist who works regular hours Monday through Friday, but hey, you need somebody to come in on the occasional Saturday. You can't ask that receptionist to come volunteer her time as a receptionist on Saturday. She's still performing her receptionist employment, and she shouldn't be volunteering to perform her job on days that she, outside of what she would ordinarily work. She's still working as a receptionist, so she shouldn't be providing volunteer services as a receptionist. There's also a distinction the Department of Labor makes between whether the services being performed by volunteers are truly charitable in nature or whether they're commercial in nature. So the Department of Labor uses the example of a gift shop. That's obviously a commercial enterprise. So there are situations where the person really wouldn't be considered volunteering for a charitable cause. But the Department of Labor does have these opinion letters, these fact sheets that do provide some good guidance on classification of workers, whether it's employees, independent contractors, or here the case of volunteers for nonprofit organizations. And I'll say too, the IRS also touches on this subject as well. They also have some good opinion letters on that are widely available on the internet as well. And I'll turn it over to Alex to talk about federal and state employment laws.
Perfect. Thank you, Bethany, and thanks, Amy, as well for having us and for the lovely introduction earlier. Appreciate chance to be with you this evening and to impart at least hopefully something helpful that you can take away as you are going about your very important and very valuable nonprofit work. I wanted to spend a bit of time on a portion, or I'll say a few spoonfuls of the alphabet soup that we're talking about here in terms of the employment laws that are at issue and that may well affect you as a nonprofit employer. Specifically, as you can see here, we wanted to talk, and I know we've touched on portions of the wage and hour considerations already. I wanted to highlight both the federal baseline, the floor of the FLSA, the Fair Labor Standards Act, and then to layer on top of that state and local considerations under Maryland law and specific county ordinances or codes that we'll get into briefly. And then Bethany is going to talk about some of the equal employment opportunity laws designed to ensure equal treatment among job applicants and employees based on certain protected statuses, both again under the sort of federal baseline, if you will, and then the heightened floor that Maryland has implemented in its laws through first and foremost, what is called the Fair Employment Practices Act, or FEPA. And then we'll also get into a couple of state-specific considerations that will apply generally across the board that you may want to keep in mind. So on the FLSA point, as you can see here, there are two basic concepts to keep in mind which will apply with equal force under Maryland law, and those are the concept of minimum wage and the concept of overtime. And so as a starting point, all employees, as opposed to volunteers, employees must be paid at least the federal minimum wage, which at this point is $7.25 an hour. Don't put much stock in that number, however, because as we'll see, the number under Maryland state and in some cases county local law is significantly higher than that. And of course, the highest number of those three figures between federal, state, and local law will be applicable to you based on where the employee is located. For non-exempt employees, and we could spend another hour or more on just the distinctions between exempt versus non-exempt employees. The concept of overtime also kicks in, which is every time that an employee works more than 40 hours in a work week in a 7-day period, they must be paid time and a half of the regular wage. So for simplicity's sake, an employee who is making $15 an hour, who ends up working 45 hours that week, needs to be paid $15 an hour for the first 40 hours, and then hours 41 through 45 would actually be overtime hours. So they need to be paid $22.50 an hour, or 1.5 times their $15 wage for each hour over 40. I've noted here, and it's something that unfortunately we see all too frequently, there are a number of employers, hopefully none of you, but a number of employers who will pay workers on a biweekly basis, and there's nothing wrong with that. That's perfectly permissible in general, but it's important to time keep or to keep records of hours worked in each week and not just each pay period, because somebody who works, for example, 45 hours in week 1 of the pay period and then 30 hours in week 2, they're still entitled to overtime for that first week, even if they didn't work more than 80 hours combined in the pay period. So just keep that distinction in mind. And you may find yourself asking, particularly when we looked at the misclassification concerns about employees versus independent contractors or employees versus volunteers. Well, even if I get it wrong, the worst case scenario is that I only owe them the wages that I should have been paying them, right? And the answer to that is no, that actually that there's a multiplier effect for getting things wrong here under the FLSA, under federal law. There's mandatory liquidated damages, double damages. So you're paying not only the amount of wages that you should have been paying the employee, but an equal amount, so double that amount total, as a penalty for violating the law. And as noted here, there is the possibility of paying attorney's fees to anybody who has to retain an attorney to file a lawsuit to get those results. I've also noted, and this is important, that owners personally may be individually liable. So how this works in practice a lot of the time is that a small business, nonprofit, for-profit, will end up having some allegations against it for not paying overtime, for example, and if that resolution proves unattainable and there's a lawsuit filed, then both the business and any individual owners, who particularly those would have been responsible for, among other things, setting your payroll policies or actually tendering that payment, may be named as a defendant too. So that can have ramifications on things like your own individual credit history, ability to obtain loans. You may have to report, you'll have a public record of any sort of judgment against you. So things that obviously any of us would want to avoid, all other things being equal. I mentioned at the start of this slide, right, that the exempt, non-exempt issue can become quite important. I mean, regardless, everybody has to get the equivalent of minimum wage. So even those people who are paid on a salary basis have to be earning the equivalent of at least minimum wage per hour, even if you're paying them on a bi-weekly or monthly basis. I've touched on here a couple of exemptions that are commonly used. There's a much more detailed factual analysis that's really required in some cases to tease out whether somebody should be properly classified as exempt and therefore not entitled to overtime versus exempt. Or versus non-exempt and entitled to overtime. Most commonly we see, right, a supervisory exemption, which requires not only supervising at least one employee, but the federal regulations specified multiple employees, among other things. And then the administrative exemption, it has to be more than, the individual has to be doing more than just rote repetition or typing of things. They have to use some amount of independent discretion and judgment before they can be considered exempt from overtime. Now, under Maryland law, then we've got the federal floor. We're now talking about the state and local raised floor here. Maryland has at least 3 laws that I wanted to highlight here. One is the Maryland Wage and Hour Law, which for simplicity's sake, you can think of as analogous to the Fair Labor Standards Act. Frankly, we see claims like could come in under both the FLSA and the Maryland Wage and Hour Law. The same basic principles apply there, except that it is a failure to pay the state minimum wage that would violate the Maryland Wage and Hour Law, which, jumping ahead to that asterisk bullet point, pursuant to the Fair Wage Act of 2023, which Governor Moore signed this session, has actually accelerated the statewide minimum wage rate. So it was always $13.25 an hour this year, but whereas before this session, the minimum wage was set to increase to $15 an hour in 2025. Essentially, all of that accelerated, moved up a year. So starting January 1 of 2024, now the statewide minimum wage in Maryland will be $15 an hour. Now, in addition to both the FLSA and the Maryland Wage and Hour Law, there's also the Maryland Wage Payment and Collection Law, which unfortunately carries with it the possibility of even steeper damages. So not just the double damages we were talking about before, but actually triple damages if there's any sort of willful violation. And even though willful violation sounds like it only covers nonprofits that are intentionally hurting or trying to withhold money from their employees, it's actually interpreted a bit more liberally than that. So it is definitely something to be mindful of. Again, the possibility of liability against not only the nonprofit, but the owners individually or anybody who is has the discretion to set payroll policy to implement that pay. And then over and above what we talked about with the statewide minimum wage, there are specific jurisdictions, and I'm thinking here of Montgomery County and Howard County in particular, where there's a higher county minimum wage. So any time you have employees working in those jurisdictions, if you're subject to coverage there, you would actually need to pay over and above the $7.25 federal floor, over and above the $13.25 state floor. In Montgomery County, for example, actually just next week or on July 1, the Montgomery County minimum wage for businesses with 10 or fewer employees will be $14.50 an hour. It'll be $15 an hour for businesses with 11 to 50 employees, and it will be $16.70 for any larger employers, meaning those with more than 50 employees. And Howard County, the minimum wage is $15 an hour there. So things to keep in mind. Obviously, if you have questions, it may be helpful to consult a pro bono or employment counsel. But I want to turn things back over to Bethany to talk about some of the protected classes here as well.
Thank you, Alex. So there are a number of laws designed to protect employees based on certain protected characteristics, such as race, color, religion, and their gender, and that includes claims of pregnancy discrimination, as well as national origin, disability, and genetic information. At the federal level, we have Title VII of the Civil Rights Act, which applies to employers with 15 or more employees and prohibits employment discrimination and retaliation based on race, color, religion, sex, and national origin. The Americans with Disabilities Act, or ADA, as it's commonly referred to. You can tell we love our acronyms in employment law.
We do.
This prohibits discrimination based on disability or perceived disability for employees of employers who have 15 or more employees. And the Genetic Information Non-Discrimination Act, or GINA, also applies to employers who have 15 or more employees and protects employees from discrimination on the basis of genetic information, such as a family history of certain illnesses or medical conditions. And as you can see here, there are certain penalties under the law ranging anywhere from $50,000 to $300,000, depending on the size of the employer, plus attorney's fees for violations of Title VII, the Americans with Disabilities Act, or GINA. And as far as the Age Discrimination and Employment Act, this protects employees it protects employees 40 years of age or older from discrimination based on age. It covers employers with 20 or more employees. And the prescribed damages under the law are a bit different here than what you see for the other EEO laws. There's the potential for double, or what we call liquidated damages, plus attorney's fees for violations of the ADEA. And the thing to note here is that an employee who feels aggrieved and feels like there's been a violation of any of these laws can't just go straight to the courthouse and file a lawsuit claiming that they've been discriminated against based on any of these protected categories, they first have to do what's called exhaust their administrative remedies. So they'll either have to file a charge of discrimination with the U.S. Equal Employment Opportunity Commission, or with Maryland's version of that, the Maryland Commission on Civil Rights. And it's not noted here, but there are also some county agencies. For example, Prince George's County has its own human rights organization. It's now called the Office of Human Rights. There is also a similar organization in Montgomery County, and Baltimore City has a similar organization. So you do have these local human rights enforcement agencies, which will also accept charges of discrimination on behalf of employees who've claimed they've been discriminated against based on these protected categories. These state and local agencies have what they call our work share agreements with the EEOC. So they try to help take the burden off of the EEOC's desk in just the number of charges that this EEOC, I see this very commonly in Maryland. I handle a lot of claims before the Maryland Commission on Civil Rights, which started at the Baltimore office of the EEOC, but then they were transferred over to the Maryland Commission on Civil Rights just because of the sheer volume of claims that come in. And the processing time may take a long time for investigation of the claim by the assigned investigator, either at the federal or the state level or the local level. And there's a lot of discretion, I think, at the state and local level as to how the investigators will investigate these claims. Sometimes they'll ask to do site inspections. They'll want to come on site and they'll want to interview various employees. They'll ask for documents. We, as attorneys helping to defend these claims and find out what happened, will help to gather up information, will help to talk to witnesses and prepare those witnesses to be interviewed by investigators at the EEOC or the Maryland Commission on Civil Rights or any of those local agencies that I mentioned previously. And now to get into a little bit more detail about Maryland's equivalent of these particular EEO laws. Maryland has its own law, which goes above and beyond the federal law, the Maryland Fair Employment Practices Act, which covers employers with 15 or more employees. And here it does have more protected categories. So it goes so far as to cover, not just gender, but marital status, sexual orientation, gender identity. And there is also a component of Maryland law, which we call a Crown Act. And so Maryland is one of the growing number of states around the country that has enacted a Crown Act. Crown is an acronym for Create a Respectful and Open World for Natural Hair. These laws are intended to protect against racial discrimination based on certain hairstyles historically associated with race, and particularly with African Americans. These laws prohibit employers from enacting grooming or dress codes that would ban certain hairstyles for no justifiable business or safety reason. Just like the federal law, there are steep penalties for found violations of the Maryland Fair Employment Practices Act. The damages awarded to employees who can prove that they've been discriminated against can range anywhere from $50,000 to $300,000, again, depending on the size of the employer, plus attorney's fees awarded to any attorney who represented the employee successfully in a lawsuit initiated under this law. And just like the federal law, an individual first has to exhaust their administrative remedies by filing with either the EEOC, Maryland Commission on Civil Rights, or one of those local agencies that I'd mentioned previously. I'll turn it back over to Alex.
Great, thanks, Bethany. And I just wanted to cover two other Maryland state and local laws that you should be thinking about, particularly with your job application forms. And the first is the umbrella of the ban the box laws. So, of course, historically, as just a reminder, many of you likely have heard of these laws, but there was a checkbox on job applications, have you ever had a criminal history or conviction? And there was, the EEOC and others have found that those types of questions actually pose what's called a disparate impact, disproportionately negatively impact communities of color and individuals of color who for reasons that may have more of a criminal record for charges, petty or significant, than other populations, and that was actually leading to unfair disadvantages in the job market. So to combat this problem, Maryland, like a growing number of states, has passed its own ban the box law, which applies to employers with 15 or more employees and prohibits those employers from asking applicants to check the box prior to a first in-person interview. So that would be even any sort of question during a phone interview would be prohibited. There are fines for each violation. They're of up to $300. Now there are 3 local or localities that have similar ban the box laws, and those are Baltimore City, Montgomery County, and Prince George's County, which apply, as you can see here, depending on the size of the employer. There are 10, if you have 10 or more employees in Baltimore City, you may not ask about an applicant's criminal history until after making a conditional job offer. If you have 15 or more employees and are based in Montgomery County, can't inquire until after the first interview. And so also in Prince George's County, the same thing, except that only applies to employers with 25 or more employees. Now, notably here, which may cover some of you, none of these laws, meaning the Maryland statewide law or the Baltimore City, Montgomery County, or Prince George's County ban the box laws, there's an exception to all of those laws if you provide programs, services, or direct care to minors or vulnerable adults, individuals with special needs. In those situations, you may ask about the criminal background and perhaps have a duty to ask about the criminal background on your application form. So definitely keep that in mind when you're considering what changes, if any, or updates need to be made to your job application forms. The other point along those lines is actually every job application in Maryland has to have, and this all caps language in bold font is actually required by law, that language that appears there under Maryland law. An employer may not require or demand as a condition of employment, prospective employment, or continued employment that an individual submit to or take a lie detector or similar test. An employer who violates this law is guilty of a misdemeanor and subject to a fine not exceeding $100. And as the language indicates, violations can lead to a fine in that amount, as well as potential criminal penalties. So it's a simple addition to your application form, but an important one. And that brings us to some reporting requirements. Bethany, do you want to take us through those?
Thanks, Alex. So just some things to keep in mind as you look to hire in Maryland. You'll certainly want to report any newly hired or rehired employees in Maryland to the state directory of new hires, and we've included the website on this slide here. Be sure to register for unemployment insurance. Be sure to obtain workers' compensation insurance. There is an entity called the Uninsured Employers Fund that is involved with the Workers' Compensation Commission, and they will get involved if somebody files a claim for workers' compensation and you don't have coverage. Once you do obtain coverage, your insurer should be reporting that you do have coverage. So it's actually searchable by database. It's easy for the state to determine if you carry coverage or not. If you have just one employee in the state of Maryland, you are required to have workers' compensation coverage. So please do keep that in mind. But Maryland's Department of Labor, and we've put the website here, it's a great resource to just go to and learn all the steps you would need to know to become an employer in Maryland, or just updates on Maryland law. So a lot of the things that we've been talking about in this presentation, especially with the ever-changing minimum wage in Maryland and in various counties in Maryland. All of that is updated frequently on the Department of Labor website. It talks about unemployment insurance and just some tips for how to become an employer in Maryland. There's plenty of information there that should be a good resource, but would also just show you where you need to go and register and possibly call in order to become an employer in Maryland. And now we'll talk about hiring and firing. So we, as employment attorneys, a lot of the advice and counsel we give revolves around these very things, hiring and firing. And unfortunately, a lot of it is the firing. It's not uncommon, especially on Friday afternoons, to get those questions. Can we fire this person? Or can you look at this severance agreement? Or here's what happened, with performance, and we want to terminate them now. So, just some things to keep in mind to make the hiring and firing process more seamless, or just performance management more generally, how to avoid some of the things that we talked about throughout the presentation with wage and hour claims, as well as allegations that you've violated any of the equal employment opportunity laws that we've talked about based on any of the protected categories, race, religion, color, national origin, marital status, anything of that nature. So I've seen plenty of, we get a lot of like attorney demand letters, things that a letter that an attorney may send on behalf of someone who just applied for a job and didn't get the job, but they think they didn't get the job because something was brought up during the interview that falls under one of these protected categories. For example, they talked about religion for a little too long in the interview. And if your organization isn't really one that is, a deemed religious organization, where that might not really be relevant to the hiring decision, or, you talked about family planning and it all of a sudden came up that this person is pregnant and they didn't get the job because they think, well, you didn't want to hire me because you assumed that I would be taking leave to care for my child when my child was born. We see those types of allegations that people weren't hired because of what was discussed during the interview, and not because, there were a number of other candidates more qualified for the job, but people will just assume that, because something discussed fell into one of the protected categories, that's why they weren't hired. You want to be mindful of what you're discussing during the interview. We're all human. We all want to get to know people and relate to people on a human level, but you do want to be mindful of bringing up topics that veer on any of these protected categories when you are interviewing candidates for the job. Whether it's marital status, family planning, as I've mentioned before. Military service is another one. I will tell you, in the past year, I've had 2 cases involving alleged violations of what they call the Uniformed Services Employment and Reemployment Rights Act. So I dare you to say that 10 times fast, but we call it USERRA because we love acronyms in employment law. But alleged violations of USERRA, because under this law, there's protection for military service members from being disadvantaged in their careers due to their military status. People who serve in the reserves and they may need to go to a training or be deployed shortly, have a right to come back to their employment and not be disadvantaged in the benefits that they receive and the opportunities that they have in their career as a result of having served in the military. I had 2 matters where people did not get jobs after they interviewed, and they alleged it was because of their military service obligations, which were disclosed in the application process and discussed during the interview process. So this is another one that you want to be mindful of. You also want to be mindful of these types of things when you're making decisions about issuing any discipline. And possible termination decisions, you really just want to make sure you're treating everyone fairly. So, for example, if you have an older worker who violated a policy and you think, you know what, he's got to go. This is unacceptable. He should know better. He's been here for however many years. Okay, well, there may be some factors there. He should know better. Maybe he's a managerial employee and he should be held, to a higher standard of accountability. But you want to be mindful of whether or not any younger employees have also committed the same policy violation, because if they aren't held accountable and he's going to possibly have a claim for age discrimination, because you've got comparators who fall outside of his protected category of age, being protected because he is over the age of 40, or just older than the individuals who aren't being held accountable for the same conduct. You want to be mindful that, everyone's being held to the same performance standards, regardless of any of the protected categories we've discussed. And I'll mention too, I know that, everyone wants to be very mindful of diversity, equity, and inclusion. And there are times when, people will sometimes, we see this with some employers, they'll, kind of set a quota. Well, we want to hire a certain number of women, or we want to hire a certain number of people from this particular racial background or national origin. Well, you really can't let any of those things factor into your hiring decisions. You want to be able to increase your DEI initiatives by expanding the applicant pool, so to speak. So be mindful of where you are recruiting from, what job fairs are you going to, where are you posting ads for job opportunities. That's really how you get more applications in the door. It's how you just open up the audience and show the opportunity to multiple candidates. But you're really veering in dangerous territory when you start setting quotas and saying, well, we need to have more women in management, so we're only going to hire women. That's when, you're making decisions based on a protected category and can potentially run afoul of EEO laws.
That's right. And the only thing I would add to that is we also see circumstances from time to time, particularly in employers that are in the service industry, where, for example, the person with whom an employee is being placed to provide services, or a customer or patron actually will request that somebody of a different, insert protected trait here, actually be the one to provide their services. And if they're making that request on the basis of any protected status, I think the law is pretty well established at this point that you have an obligation as an employer not to take action against the employee based simply on that request. And the customer made me do it defense really has fallen very flat in court. So our advice there, generally speaking, things to think about, I should say, would be, is there a way that I, as the manager of the nonprofit, can work through the issues with the customer, find out what it is that seems to be the problem, and try to find a constructive way to work through it. And then obviously, if there's no ready solution, there are certainly sources of advice and counsel that you may want to seek. And one other piece on the hiring and firing component of things. Apparently, I'm the dollar sign guy tonight, but with respect to non-compete agreements, so you may have contracts with your employees that say, for a period of X months or even years, after my employment, I will not work with any of your organization's competitors in a specific geographic area or providing the same types of services. Something to keep in mind here, Maryland law actually prohibits those for more middle class employees here, which specifically the threshold right now, anybody who's earning less than $15 an hour, less than $31,200 annually, may not be subject to that type of non-compete agreement. The rationale basically being that those types of individuals are typically not privy to top secret information that would actually be of concern if that individual were to have mobility in the workforce to work for a competitor. And then importantly here, that threshold's actually increasing to 150% of the state minimum wage. So you can see the equivalent figures in the brackets below. What that really means as a practical matter is if you have anybody who's earning between $31,200 an hour and really 50% more than that, so $31,200 to $46,800, you should be thinking now about modifying those agreements so that you don't run afoul of Maryland law by starting in October or in January. If you have any questions, obviously we're happy to help. And on the subject of written documents that help guide everyone's obligations, we wanted to spend a few minutes here as we wrap up before turning to any questions on just the areas of employee handbooks and bylaws. And I think consistent with a lot of the laws we've been talking about, the EEO laws, wage and hour laws, if you have an employee handbook, it's certainly worth considering having basics in there about how employees are going to be paid. How often are they going to be paid? What types of categories of employees do you have? Is there a difference between how you're treating exempt and non-exempt employees? Do you have an anti-discrimination or EEO policy? Do you have a complaint reporting policy that explains, among other things, to whom or what type of conduct is prohibited, to whom those complaints can be made, and language that indicates that any complaints will be taken seriously, will not be, the people bringing the complaints to you will not be retaliated against for making those complaints, and that the complaints will be investigated promptly and thoroughly. These are all things to consider when you are either drafting or updating your employee handbook, given the constantly evolving nature of these employment laws. As we've seen on the slides, we certainly recommend doing sort of a self-audit on a regular basis, meaning at least an annual basis, to identify what, if any, areas need to change. But in any event, the structure conceptually for employee handbooks is that they should be up to date. You should be prepared to follow whatever policies you have in your handbook. And you may also want to include disclaimer language in there, just indicating that nothing is in the handbook is intended to create a contract of employment, if that's the case, and that that they're still at-will employees. But in any event, things to keep in mind there, that's a more fluid document, for example, compared to bylaws, which are more like the constitution of your nonprofit and can provide important context for how the organization is intended to operate and to make decisions. Most importantly, I think, is the bottom point here, which is that the bylaw should explain who or which office has the authority to make those decisions. But Bethany, do you want to bring us home here?
Yeah, and so just to summarize, employee handbooks are primarily intended to inform your workforce what's expected of them. So those points that Alex made earlier, your policies, and please make sure they are your actual policies and not some that you just pulled off of the internet, because
Yes.
there are plenty of just template employment handbooks on the internet. And I've certainly had those discussions with clients in the past where, that's not really our discipline policy. Okay, well, it shouldn't be in there because some attorney might find, some claimant's attorney might find this and think that's the policy. I mean, what's in there should actually be what your company's doing, what your policy is. It shouldn't just be, this aspirational or policy that doesn't even apply to your company. You want to make sure it's accurate and that it's up to date and consistent with the applicable law. Your bylaws, by contrast, are intended to clarify who among your members of management, especially your board of directors, has power to make certain decisions on behalf of your organization. Often I see, the bylaws will dictate who has authority to make employment related decisions with respect to the CEO or president of the organization. That person typically has to answer to their board of directors, and oftentimes the board of directors will empower that CEO or president of the organization to then make staffing decisions for employees of the organization. So you want to be sure you're clear about just the management structure of the organization in the bylaws, who has what authority to make what types of decisions, whether it's budgeting and budgeting for what, and hiring, firing, those types of decisions should all sort of be set out in the bylaws for your organization.
Absolutely. So with that, I think we'd be happy to take any questions here. I know that some have been in the chat, and so we can walk through those. And if there are other questions now, I think can open things up here. So I just, and please, I guess Amy will tag you in as sort of our backstop here if there are questions that we missed. But just to go through, I'm seeing, right, if somebody's asked